Okay, I need you to understand what just happened in a federal courtroom, because this almost never occurs in American legal history. A former First Lady of the United States is reportedly on a path toward being compelled to testify under oath about her marriage, her residency claims, her tax filings, and aspects of her personal history that have remained carefully shielded from public scrutiny for decades. Not in a memoir, not through carefully managed interviews, in federal court under penalty of perjury. And here's the part that makes this moment genuinely extraordinary. According to legal analysts, this situation was not created by political opponents or hostile prosecutors. This appears to be the direct consequence of strategic decisions made by Melania Trump's own legal team. Decisions that legal experts are now describing as potentially catastrophic errors in judgment. If you value deep analysis that connects legal strategy to real-world consequences, make sure you're subscribed to this channel with notifications turned on, because what unfolds from here will set precedents that extend far beyond one family's legal troubles. What we're witnessing didn't begin in a courtroom. According to multiple reports, it began with a threat letter. The kind of letter that has, for decades, terrified journalists, publishers, and media companies into silence. In October of last year, veteran investigative journalist Michael Wolff reportedly received one of the most aggressive legal threats imaginable. A demand letter alleging defamation and warning of potential litigation, seeking damages that sources describe as being in the billion-dollar range. The message, according to those who have reviewed the correspondence, was unmistakable. Retract everything you have written about alleged connections between Melania Trump and figures from Jeffrey Epstein's social circle. Issue a public apology or face what was framed as total financial annihilation. The letter reportedly came from a Florida-based attorney who has quietly become a go-to legal enforcer for matters connected to the Trump orbit. This represents what legal analysts identify as a classic intimidation playbook. You don't argue facts in public, you threaten overwhelming litigation costs and dare the other side to survive it financially and emotionally. And according to lawyers who specialize in media law, this strategy works most of the time. People fold, they publish humiliating walkbacks, they issue corrections, or they simply go quiet and hope the storm passes. Because fighting back against potential nine-figure liability is usually considered career suicide. That's exactly why what happened next is so significant. Michael Wolff is not a casual blogger. He is a journalist who has already survived years of legal pressure and emerged largely unscathed. He has written multiple best-selling books examining the Trump White House, books that exposed internal dynamics powerful figures desperately wanted buried. So when Wolff reportedly received that demand letter, sources say he did not panic. He did not apologize. He did not retreat. Instead, according to court filings that are now public record, he did something that flipped the entire power dynamic. He went on offense. And that single decision is what transformed a routine intimidation tactic into what may become one of the most invasive legal exposures any First Lady has faced in modern American history. What happened next is the moment this case stopped being routine and became what lawyers are calling radioactive. Because instead of reacting the way the legal strategy apparently expected, Michael Wolff, according to publicly filed documents, sued first. Let that sink in. Instead of waiting to be dragged into court under the weight of a potential billion-dollar claim, Wolff went straight to New York State Supreme Court and filed what legal experts call a preemptive declaratory judgment action. This is almost unheard of in modern litigation. And court documents suggest it was a deliberate, calculated decision designed to accomplish one thing: force the entire dispute into daylight, into public court filings, under rules of evidence and constitutional law. In that filing, which is available on the public docket, Wolf reportedly did not hedge. He laid out every single statement Melania Trump's attorneys allegedly claimed was defamatory and addressed them one by one, methodically, on the public record. He explained why each contested statement fell into one of three protected categories. Either it was factually accurate and supported by documented reporting, or it was clearly opinion, protected by the First Amendment, or it had allegedly been deliberately stripped of context to make it sound more scandalous than it actually was. But Wolf didn't stop there. He escalated. He accused Melania Trump and her attorneys of engaging in what legal experts call strategic lawsuits against public participation, commonly known as SLAPP suits. These are not lawsuits designed to win on the merits. They are lawsuits reportedly designed to scare critics into silence, bleed them financially, and send a message to everyone else watching. By suing first, Wolf forced Melania Trump into a position she has spent her entire public life avoiding: participation in a legal process with discovery rules, deadlines, judges, and sworn statements. The moment Wolf filed that case, the traditional playbook lost its greatest weapon: fear of litigation. And that is when Melania Trump's legal team made the decision that would change everything. Once Michael Wolff forced this dispute into the open, Melania Trump's legal team reportedly faced a problem. They could no longer rely solely on intimidation. They now had to choose a legal battlefield. And according to publicly available court filings, that's when they made a move that on paper appeared strategic. Rather than litigating the case in New York State court where Wolf had filed, Melania Trump's attorneys attempted to remove the case to federal court. This is a common tactic in high-stakes disputes. Federal courts have different procedural rules, and defendants often believe federal judges may be more predictable than state court juries. But there was something else at play here. Through what court records describe as random judicial assignment, the case reportedly landed in the courtroom of a federal judge who was appointed by Donald Trump himself. From the outside, this appeared advantageous: a potentially familiar judicial philosophy, a federal forum, what may have seemed like an opportunity to manage the case more quietly. And for a brief moment, it probably looked like strategic positioning had worked. But here's what legal experts say most people are missing. Federal jurisdiction comes with strict requirements. You cannot simply ask a federal court to hear your case because you prefer federal rules. You must demonstrate that federal jurisdiction is proper. There are only specific ways to do this. One way is diversity jurisdiction, which requires that all parties be citizens of different states. If Melania Trump is a citizen of Florida and Michael Wolff is a citizen of New York, diversity jurisdiction might apply. But there's a problem. Multiple reports and public records suggest Melania Trump maintains significant connections to New York. She has reportedly been photographed in New York regularly. Her son attends school in New York. And if Melania Trump is actually a New York resident for legal purposes, diversity jurisdiction collapses entirely. This is where the case becomes genuinely dangerous for the Trump family, because federal courts do not simply take your word on residency. They investigate. They issue discovery requests. They demand documentation, tax returns, voter registration records, mortgage documents, school enrollment records, credit card statements, anything that establishes where someone actually lives, not where they claim to live for strategic purposes. And this is the trap. By moving the case to federal court, Melania Trump's legal team reportedly opened the door to precisely the kind of invasive scrutiny that powerful families typically spend enormous resources avoiding. The irony is particularly stark. They moved to federal court apparently hoping for more control. And in doing so, they potentially triggered discovery obligations that may force Melania Trump to answer under oath questions she has never had to address publicly. Legal experts emphasize that residency is not a casual question in federal litigation. It determines jurisdiction. And jurisdiction determines whether a federal court even has the authority to hear a case. If residency is contested, which multiple reports suggest it now is, federal procedural rules reportedly require that judges allow full discovery on that question. That means depositions, that means document production, that means sworn testimony. And that means Melania Trump may be compelled to sit down in a deposition room and answer questions like, where do you actually sleep most nights? What address do you list on your tax returns? What state do you claim as your primary residence? Where does your son go to school? How many days per year do you spend in Florida versus New York? Where do you vote? Where do you maintain your driver's license? Do your public statements about residency match your private legal filings? These are standard discovery questions in federal jurisdictional disputes. And once those questions are asked and answered under oath, the answers become part of the permanent litigation record. They can be compared against tax filings. They can be cross-referenced with public statements. They can be analyzed by other investigators. This is why experienced attorneys typically advise clients to avoid federal court unless they are absolutely certain their jurisdictional claims can withstand scrutiny. Let me pause here to explain why this matters beyond one family's legal strategy. This case tests something fundamental: whether powerful individuals can invoke the benefits of federal jurisdiction while avoiding the obligations that come with it. Federal courts offer advantages, potentially more favorable procedural rules, potentially more predictable outcomes, access to federal appeals courts. But those benefits come with a price: strict evidentiary requirements, mandatory disclosure obligations, and no special exceptions for political figures or former first ladies. The judge overseeing this case now faces what legal analysts describe as a straightforward decision. If residency is legitimately contested, and multiple reports suggest it is, the judge must allow discovery. There is no discretion here. Judges do not get to waive jurisdictional requirements out of sympathy, political alignment, or concerns about privacy. Jurisdiction is a threshold requirement that must be established before any court can proceed. This is where the situation becomes particularly problematic for Melania Trump. Even if she ultimately prevails on residency, the discovery process itself may produce revelations that create entirely new legal and political problems. Tax filing discrepancies, conflicts between public statements and private documents, patterns of behavior that raise questions about other legal claims the Trump family has made over the years. And there's another layer of complexity here: Barron Trump's school enrollment. Multiple reports indicate that Barron attends university in New York. That fact alone may be devastating to Melania Trump's claim of Florida residency. Family law specialists note that courts generally presume parents maintain residency where their dependent children attend school, particularly when those children are still living at home or receiving substantial parental support. If Melania Trump testifies under oath that she is a Florida resident, but Barron attends school in New York and she spends substantial time there, that creates what lawyers call a credibility problem. And credibility problems in federal court have consequences. Judges notice inconsistencies. Opposing counsel exploits them. And once testimony is given under oath, it cannot be walked back without serious legal exposure. Here's what makes this situation even more complicated. Even if Melania Trump somehow navigates the jurisdictional discovery without major damage, the underlying defamation case appears astonishingly weak. When you examine what Michael Wolff actually wrote, the foundation of Melania's claims reportedly becomes very difficult to sustain. Defamation law in the United States sets a very high bar, especially for public figures. And Melania Trump is not just a public figure. She is a former first lady. To win, she must reportedly prove that Wolff made false statements of fact, that he knew they were false or acted with reckless disregard for the truth, and that they caused measurable harm. Opinion does not qualify as defamation. Context matters enormously. Documented reporting is protected. Wolf wrote that Melania Trump had connections to social circles that overlapped with Jeffrey Epstein's network. That is not speculation without foundation. It is analysis based on publicly documented facts about modeling agencies, social networks, and historical timelines. He wrote that she may represent what he called a missing link in understanding Donald Trump's relationship with certain figures from that era. That is plainly framed as analysis and opinion, not a provable statement of fact. And opinion is protected. He referenced what he described as overlaps involving modeling networks during a specific period. Those elements are part of the verifiable historical record, including Melania's work with agencies that have been documented in connection to figures in Trump and Epstein's social orbit. None of this is reckless fabrication. None of it appears to be anonymous rumor presented as fact. It is contextual reporting layered with interpretation. That is precisely what the First Amendment protects. Which raises the unavoidable question, why take this risk? Why expose your residency, your tax filings, your marriage, and your private life to sworn scrutiny in federal court to pursue a case that legal experts suggest you are likely to lose on First Amendment grounds? This is why some legal analysts quietly describe this as approaching what they call malpractice territory. Someone should have stopped this. Someone should have explained the cost-benefit analysis. Someone should have said no. Instead, Melania Trump pressed forward, and now she is reportedly facing the most invasive legal exposure of her public life to pursue a defamation claim that may never survive summary judgment. And in the next phase of this story, the question is no longer whether she can win. It's whether she can escape at all. At this stage, the most dangerous reality for Melania Trump is not even the specific questions she may face. It's the fact that there is no clean exit anymore. Every available option reportedly comes with severe consequences. One possibility is to voluntarily abandon the attempt to stay in federal court and ask that the case be remanded back to New York State court. But doing that would require publicly acknowledging what would be obvious to every legal analyst, that the removal was a strategic error, a miscalculation that triggered discovery obligations the legal team could not control. That kind of retreat is rare in high-profile litigation, and it reportedly invites even more scrutiny. Another option is settlement. But that door appears effectively closed. Michael Wolff has shown no interest in backing down. He did not sue first to quietly compromise. He sued first to force transparency, to establish precedent, and to put what he has described as an intimidation strategy itself on trial. Settlement would deprive him of the very discovery that makes this case significant. Melania's team could attempt to limit discovery, arguing that questions about personal life are overly intrusive. But federal procedural rules leave very little room for discretion on jurisdictional disputes. If residency is legitimately contested, discovery must be allowed. Judges do not get to waive jurisdictional requirements because of privacy concerns or political considerations. That leaves the most likely outcome. The case proceeds. Discovery moves forward. Depositions are scheduled. Melania Trump potentially sits down under oath and answers questions about where she lives, where she sleeps, how often she is in New York versus Florida, and what her financial and tax records actually show. Her answers are recorded, transcribed, preserved. And once those answers exist, they do not disappear. They become part of the litigation record. They can be referenced by journalists. They can be analyzed by other investigators. They can be compared against public statements and prior legal filings. This is a nightmare scenario for any public figure built on carefully managed narrative control. For decades, litigation has been used as a tool to intimidate critics into silence. But this time, the strategy backfired. The legal machinery relied upon to suppress information is now potentially forcing it into the open. And for Melania Trump, the timeline is no longer moving toward victory. It's moving toward testimony. When you step back and examine what is happening here, the significance extends far beyond one lawsuit or one family. This case reportedly exposes what experts describe as the core weakness of intimidation-based legal strategies. They only work as long as no one fights back. Threaten lawsuits, inflate potential damages, intimidate critics. Most people retreat long before a judge ever gets meaningfully involved. And because of that, the facts never have to be tested. The documents never have to be produced. The answers never have to be given under oath. Michael Wolff reportedly broke that cycle by suing first. He forced a confrontation in the one arena that intimidation cannot control, a courtroom governed by procedural rules rather than financial leverage. In that arena, power does not come from threats or resources. It comes from evidence, from consistency, from verifiable truth. We are not watching speculation anymore. We are watching what happens when accountability mechanisms are finally triggered, when procedural rules are enforced, and when powerful figures must answer questions under the same legal standards that apply to everyone else. What happens next will set precedents that extend far beyond this courtroom. Make sure you're subscribed, because this story is far from finished. And what develops next will be something we all need to understand.